It is amazing that you can actually convict a student, that's effectively what these kangaroo courts do, of sexual assault, rape, take away his college career, his scholarship, if any, his future prospects in corporate America, without the right to cross-examine, with no right to cross-examine or even potentially to see all the evidence, and in front of a body that is nowhere near qualified to hear such evidence, and, as you've pointed out repeatedly, is always stacked in favor of the accuser.
I mean, the biggest change in these regulations, the current regulations require all of the things that you just mentioned: a hearing, cross-examination, all access to the evidence. The current regulations allow, or these new regulations will allow for a school's Title IX coordinator herself. She doesn't even have to hire anyone to do this, to conduct all of the investigation. There'll be no hearing at all. Instead, there'll be individual interviews with the witnesses. The accused student will not see or hear in real time the questions that are being asked of his accuser, won't be able to hear that testimony in real time. And then the single investigator, without any hearing at all, will be able to pass judgment. And as you pointed out, this is not a criminal court, right? But the life-altering effects of a guilty finding in a Title IX process are, they're just that. They ensure that the student is likely to be expelled. The chances of getting into graduate school are zero. It will be on their resume for the rest of their lives, and so any chance of a good job is going to come up there as well. Certainly, if a student commits sexual assault, he should be punished for this. But the purpose of the process should be to determine the truth of the allegation. It seems like with these regulations, instead, the purpose of the process is to encourage reports by telling complainants, look, you won't get asked tough questions. It will be one-sided. Don't worry about it.
You'll never even have to be face-to-face with him. And anybody who's ever been in a courtroom setting understands it's very important for the accused to sit there and be able to hear the allegations against him, because he can sit there and lean over to his lawyer and say, that's not true. She's misstating that. That one key detail was changed and it matters. Here's why. If he's not present to listen to her accusations against him, how is he supposed to meaningfully fight? And by the way, you and I have been doing this long enough that I know the cases you've worked on, some of them. And just for the audience members out there who might be thinking, it's very rare for a woman to make up these stories. All right, get out of your head the Duke lacrosse fake victim. She's the most extreme case. She was a nutcase. She was a, prostitute. She was being pimped out by the boyfriend, and she decided to make up this terrible lie. These three guys had not touched her, and she almost sent them to prison. That's the most extreme. But there are many cases of what we might have called a one-day Sunday morning regrets. Women who have all sorts of reasons to regret sleeping with a man consensually, who then either get pressured by their friends or their boyfriend who they were cheating on, or someone in their dorm, into turning it into a sexual assault accusation.
Absolutely. I mean, the classic case in this area, I think it was the first time that we talked around a decade ago, was this case at Amherst, where a female accuser seduced her roommate's boyfriend, who was heavily intoxicated at the time. Word got out what she had done. She lost all of her friends, which is kind of unsurprising. And then, as part of a campus climate that encouraged students to think of uncomfortable sexual encounters as sexual assault, she filed a Title IX complaint against the student. She, through what was an obviously kangaroo court, she was able to get the guilty finding. He was expelled, and only when he filed a lawsuit did it come out that during that evening she had been texting two different people, one of whom she admitted in the text that she needed to come up with a good lie, and so that the evidence there was unusually strong. And in that case, the Amherst investigator, who under the current regulations will now be entitled to pass judgment herself, the Amherst investigator said that the fact that the accuser was texting at the time, saying it was consensual, saying that she needed to come up with a lie to explain for seducing her roommate's boyfriend, that evidence didn't matter, that the only evidence that matters in cases like this is once the accuser decides that it was sexual assault, then what she says matters. But before that, she could say anything that he wants. That's a crazy standard. And that's a standard that's obviously unfair in a courtroom that would never be allowed. But in these closed Title IX proceedings, which again, no longer even have to be hearings, they can just be an investigator passing his or her judgment. It's an inherently unfair process.
It was the Amherst case was one of the most disturbing. There was also the Oberlin case that you and I talked about one time. Can you go through some of the facts of that one? Because that was another one in which the guy was appointed, an accuser's representative who was a believe all women guy.
This Oberlin case was just an amazing one where you had a one night stand. The student, both students were intoxicated, but neither were incapacitated. And under Oberlin's regulations, it said that there could only be sexual assault if a student were incapacitated, not just merely drunk. But the student was nonetheless found guilty. And he was found guilty, first of all, because the Title IX coordinator was on record saying that in cases that are kind of gray cases, where we might have a doubt between a woman and a man, we need to give the benefit of the doubt to the woman. And then secondly, this Title IX coordinator had appointed as the advocate for the accused student someone who not only left the room during the middle of Oberlin's hearing, but then tweeted out, as you mentioned a couple of weeks later, that it was his cardinal principle to believe all survivors. And this would be as if in a criminal process, the district attorney prosecuted the case and then got to appoint his deputy as the person who would be the defense counsel for the accused. It's Orwellian. But in the Title IX process, where the Title IX coordinator is under heavy pressure from the federal government, from various campus constituencies, from victims' rights groups as a whole, to come down with guilty findings, these kinds of events are all too common.
Are you passionate about protecting civil liberties like free speech? Well, I've got something special for you. You could consider opening a Donors Trust charitable giving account, a donor-advised fund designed specifically with your values in mind. Imagine being able to support causes that you actually care about, all while safeguarding the principles that matter most to you. Whether it's defending free speech, promoting limited government, or supporting individual rights, your contributions can make a difference. It's straightforward giving, so you can focus on what truly matters, making a positive impact. Your donations are securely managed, ensuring your hard-earned money goes exactly where you intend it to. Plus, with built-in safeguards, you can trust that your support is being used effectively and responsibly. So if you're ready to make a difference, go to donorstrust.org/MK today to download the ultimate survival guide to charitable giving. Learn more at donors, trust.org/MK. donorstrust.org/MK to download the Donors Trust Giving Guide today. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.